Good day, Crime Talk aficionados. We have another great show for you, even though we're on the road. First, Bryan Kohberger. Did he tell us how he was going to commit the perfect crime? Lori Vallow helps select her jury. The Karen Reed trial gets underway, also jury selection. A 75-year-old woman is charged with the death of her child from 55 years ago. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment down below. Hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. As you can see, we are on the road again. That's right. Same client, second trial. I'll tell you more when it's over. I just don't know when that's going to be over. All right. So let's get to the show. First, go to crimetalksearch.com. Sign up for a background subscription service today. When you do, you'll be able to do as many background searches as you desire. This could be somebody coming into your life, maybe somebody you're not sure about. Maybe it's the parents of those kids that are hanging around with your kids. Maybe not giving you that warm, fuzzy feeling. Go check them out. You sign up for that background subscription service, which you can cancel at any time. So whether you want to do 1,000 searches or one, you can do that. Literally, a report is generated while you wait. It is emailed to you, and you can get updates if any of the information changes. And you're going to get all types of information as to social media presence, telephone numbers, email addresses. Does somebody have a criminal history? Do they have liens, bankruptcies? Are they on a sex offender registry? Yes, all those things that you want to know, things you need to know. Heck, it could possibly even save your life. So go to crimetalksearch.com. Sign up today. You're going to be happy that you did. All right, let's go ahead and get to the docket for April 1st. That's right, ladies and gentlemen. It's April Fool's Day, but we are not making anything up. We don't mess around when it comes to the facts. All right. So yesterday, we brought you, I went through a lot of the motions that had been filed, and I wish I hadn't had the delay of a couple of days from when they were filed or released in the Bryan Kohberger matter. But like I said, I was in trial all last week, and yes, we got the big not guilty. I guess we'll see if lightning strikes twice in 2 weeks. We'll have to wait and see. Anyway, one of the motions, and it was the motion regarding self-authenticating records that I really want to talk about first. And this was all the video cameras and various receipts for purchasing scarves and all that kind of stuff. But one of the items was a report, a final report that Bryan Kohberger did as part of his PhD program. And the district attorneys want to be able to have this document written by Bryan Kohberger as part of his final exam to explain why there was so little DNA evidence in the case. Now, you may think, well, how is that going to come into evidence, right? I mean, they can bring in the professor to say this is a report written by Bryan Kohberger, and it purports to be that as a report written by Bryan Kohberger. We'll pull this up. And this is on page 34 of 70 of that motion in limine. All right. And remember, how many times have I said it? It's always the defendant's own words that get them in the end. It always happens that way. Trust me on this. All right. So we have this report. It's dated Bryan Kohberger. Goes to Professor David Seip, S-E-I-P. Hope I'm pronouncing that correctly. And it's a criminal justice class, a 361 level, so upper level course, and it's dated 5/5 of 20. Okay. Now, this isn't like a confession written after the alleged crime or the crime that took place. Obviously, and we'll give Bryan Kohberger the presumption of innocence because he's entitled to that. But this is going to come in as a self-authenticating document. At least that's what the prosecutors are going to try to say it is that, this was turned in by the professor, turned into the professor, and it's a crime scene scenario final. Okay. Well, you may say, first of all, this is a final written for a paper, for a hypothetical exam. How is that relevant? Well, if you go to under Rules of Evidence 401, does it make an element that the prosecution has to prove beyond a reasonable doubt more likely or not? The prosecution is obviously arguing that it makes it more likely to explain why there was basically a clean crime scene with lack of DNA and lack of evidence. Okay. Except for that little itty bitty knife sheath for that K-bar. And if I was back in the CrimeTalk studios, I would pick it up and show you. All right. It's not a small knife. And so I want to go through it. And then you let me know why, if you believe this is relevant. I think the judge is going to allow it in. All right. You have to go 401, right? Is it relevant? Then you have to jump kind of a 403 analysis. Is the probative value more beneficial probative than it is prejudicial to the defendant? Would it give it, that would be so overwhelming prejudicial to the defendant that's just not fair? That'll be for the judge to ultimately decide, but I don't think it is. And like I said, it comes in, frankly, as an admission or statement by a party opponent, right? Anything that the defendant makes is not hearsay. Anything the defendant says is not hearsay. So let's go through. This is his crime scene scenario final, dated 5/5 of 2020. First, arriving at the crime scene. The first thing to be done is to block off the crime scene in order to avoid crime scene contamination. Keeping people out of the scene minimizes evidence contamination, though many may be curious to see what occurred. The theory of transfer states that we bring something with us to a crime scene and take something away, thus skewing the crime scene from the original state by contamination. This is because the original state of the crime scene was left by the criminal suspect. A lack of contamination allows the scene to be a snapshot in time. The curious must be noted and immediately evicted from the scene. People to be kept out of the scene include unauthorized civilians and the obsolete minimum number of law enforcement agents and forensic crime scene processors. Waiting for backup to arrive, I should stand guard at this scene, preventing these unauthorized people and even holding back eager officers from entering the scene. I must call my immediate supervisor and inform them of the deceased white female who is approximately 35 years of age. I must obtain an initial search warrant to search the scene. Failing to do so will mean that the evidence is inadmissible. This is another reason why holding personnel from entering is key. The coroner must be called in order to pronounce the woman dead, and EMS should be called if they were not already called by the patrol officer 15 minutes earlier, and they would have provided emergency care if the woman showed signs of life. This would have been important for many reasons. Her livelihood is one reason, but from the stance of a patrol officer or criminal investigator, she may have given a dying declaration of her attacker when informed of her impending death. Forensic services are next to be on the list to be called, as they are best equipped to handle the evidence, process it, and ensure there is not any contamination. Their van also contains the best equipment for a forensic investigation. A cursory search of the immediate area should be done, and any observation should be recorded in my field notes as to ensure the integrity of the preliminary case reports. Officers who are not needed at the residence should ensure that the general area is searched for anything that stands out as well. This includes the area of the trailer park, which contains 62 trailers. If there is anyone in the trailer, they should be moved out and questioned. Does she have kids? I should gather the following information in my notes as the investigation commences, which will later be included in my preliminary case report when the details of the case culminate. The offense, the date and approximate time of the offense if known, identification of the victim, the location of the offense, the method of operation if known, and the identification of the officer. Since the offender was not there, I would be unable to record this information initially, and the specifics of the crime won't be known until confirmed by the crime lab. Getting the approximate time is important and can be indicated by rigor mortis, which sets in at about 12 hours, or putrefaction, about 10 to 20 days. All this information will aid me as I attempt to reconstruct the scene of the crime based upon the evidence location in relation to its former known position. Equipment I will have on hand for the investigation. To prepare for crime scene investigation, I must ensure I have a crime toolkit containing the following: a 35 millimeter camera or digital camera capable of videotaping with the adequate supply of film and power, a portable lighting system ensure the quality photographs and that I do not miss or step over any evidence, assorted steel tape measures that can reach at least 25 feet, a ruler or measure marking device, latent fingerprint equipment, gloves to protect the scene from contamination. This will enable that I avoid leaving my latent fingerprints, forceps and small tweezers and a pair of scissors, a small saw to take evidence, for example, drywall, filter paper or small swabs for liquid evidence or trace evidence, various evidence containers for liquid and solid evidence, paper envelopes for physical evidence, evidence tape to seal off the evidence container, casting materials to take molds of possible footprints around the perimeter with a rubber container for the mixture, a magnifying device should be kept, crime scene tape for the scene, protective clothing, boot covers, eyewear, fiber-free overalls, face masks, hair nets, gowns, and anything that will prevent me from contaminating the scene with things I bring with me. A blue light and yellow glasses will make small trace evidence more visible, can be used to ensure that a photo is taken of all evidence. This could be a very small amount of blood somewhere, which wouldn't have been sampled, documented, or photographed otherwise. Entering the home for crime scene documentation, initial photography, videography. I may enter upon judicial approval of the search warrant and should do so with the minimal number of personnel. Having too many personnel evident in the photography may put the integrity of the evidence into question and taint the scene. A contamination list should be made, documenting every person who enters and exits the crime scene and why. This includes first responding officers, firefighters, EMT, family members, criminal investigators, and all crime scene personnel. Still, there should not be that many people in the crime scene. Otherwise, contamination will be increased as the theory of exchange inevitably manifests. I must ensure that myself and my fellow crime scene personnel are wearing gloves and other protective equipment as to avoid contaminating the scene with latent fingerprints. A fiber-free boot cover would also be ideal to avoid leaving physical footprints or residue from the boot. Anything that is fiber-free and covers the mouth, hair, and overall body would be helpful in avoiding crime scene contamination, since hair, saliva, skin cells, and other bodily fluids or cells may be added to the scene, thus contaminating it. Fibers can be left via the theory of exchange and would contaminate the crime scene from its initial state as the offender left it. Even if we can't assume that there was an offender, despite seeming obvious, preventing contamination is an important way to ensure the integrity of the investigation and the evidence. We would always treat the crime scene as if there is indeed a criminal homicide, as to not miss out on important details. This is how this crime scene is being handled. The first thing to me to do is to take a coordinate series of crime scene photographs with a digital photography device or a 35 millimeter camera with a natural point of view. These photographs must be taken prior to the movement of any object in the crime scene to ensure that the photo captures the scene as the offender left it. The photograph should be taken from a general view from the exterior of the home, as well as the general view of the interior, recording the time and details of the photographs in my notes. Setting up portable lighting ensures that the elements of the crime are adequately illuminated for photographic documentation. The photos should be in color to provide the best, most accurate images, thus avoiding photographic distortion. The following details regarding photography should be recorded in the field notes on the back of the photos if possible. Recording these details will ensure the defense attorneys do not attempt to devalue the quality of your evidence, which may make it inadmissible. Data to identify the subject of the photograph, but without too much unnecessary information. The location of the photograph, including the state, city, and street address. The identifying data of the photographer, including the name, police agency, badge number, and identification number. The case number, if established at the time of dispatch. The precise time of the photograph. The date the photograph was taken. The weather at the time. And the photographic equipment used, included shutter speeds, film type, and developing and printing techniques. Next, photos of specific rooms should be taken with special attention to the living room in which the deceased woman was found. As the coordination of photos is focused inward, specific components of the crime, like physical evidence, should be accounted for and detailed. These should also be logged in the field notes. This physical evidence should be photographed next to a measuring marker, which can be a ruler or any easily comparable object of well-known size. The body and physical evidence to take a picture prior to the collection from forensic services and criminal investigators include the deceased woman in the living room, who should be photographed under adequate lighting for a long view. Specific shots should be focused on the evidence of harm on her body and clothing, the bruises on her face, the marks on her neck, the bloody shirt, and any other signs of postmortem lividity should be photographed and taped without moving the victim. A measurement marker should be placed next to her. This will show if an offender moved the woman as to manipulate the crime scene. Does she have defense wounds? Are there hesitation marks on her related to the knife? Or are there multiple stab wounds? These must be photographed and taped. Is the mark on her neck related to the hanger near her? The photograph makes sure that the items were indeed present at the crime scene. Most of these questions are speculated until absolutely confirmed by the forensic medical examiner, who can use the scientific equation to determine the approximate time of death. This is a maxim that stands even when the scene seems to point to the obvious. The time of death is never entirely accurate, but the photographs can aid in this process as they capture the phenomenon such as rigor mortis or putrefaction when the woman was found. The knife should be photographed under adequate light, and markers should be placed next to the knife to give the best photographic representation of the evidence. The misshapen coat hanger should be photographed under adequate light, and measurement markers should be placed next to the evidence. The upended furniture and children's furniture should be photographed firstly from a long view, and then focus specifically on each piece of furniture under adequate lighting with measurement markers. All of this should be well documented in the field notes on the photograph. If there is any sign of forced entry into the home, this would be evident by broken glass from window and pry marks on the door or windows surrounding the house. This should be photographed, videotaped, and documented. If there's no forced entry, it may be suggested that the woman knew her killer. A video camera will be used, as well as all of the other evidence which was photographed. Documentation of the video evidence should also be filled out and recording the field notes. The crime scene sketch. The crime scene sketch occurs after the scene was initially searched, photographed, and videotaped. The sketch is of great value in criminal court. This sketch should first be done in pencil to ensure that the sketch accurately portrays the evidence measurements pertaining to the crime scene. The final version will be done in a non-perishable ink via pen. The physical evidence of the crime, which includes but is not limited to the knife, misshapen coat hanger, furniture, as well as other biological evidence like bodily materials or fluids, should be drawn out in accurately measured proportions from each of the permanent objects in the crime scene sketch. The final search and confirmation by the forensic processing unit investigator will determine whether this was all physical evidence at the scene. New evidence can be added to the crime scene sketch when new measurements are taken. The distance from permanent fixtures should be adequately recorded and depicted. The crime scene sketch should be measured by the criminal investigator and accurately display the proportions of the physical evidence. Any inaccurate portrayal of the location of evidence can influence the juror perception of the guilt or innocence of the suspect. While you need to be an artist, the responsibility of sketching should be taken with accuracy and a goal for a clear portrayal in mind. Though I can assign other officers to sketch, I have decided to take this task on. A 25-foot steel measuring tape should be used to record these exact and accurately recorded measurements of the physical evidence and the permanent objects in the house. Too much detail shouldn't be included in the sketches to avoid confusion. Movable items unrelated to the crime scene convey details irrelevant to the crime and will be avoided. Extraneous detail, including movable furniture, may cause issues if jurors recognize that items in the house were moved after the fact. This would be equivalent to a crime scene contamination and may render evidence inadmissible. The living room should be sketched out with the deceased woman being drawn in proportion to the knife, coat hanger, and upended furniture and children's furniture, walls, and permanent objects in the house, and others that are relevant should be included in the sketch. I have decided to use a rectangular coordinated method which two right angles being outlined in proportion to the physical evidence and permanent fixtures centering around the living room. A projection can be used to document biological trace evidence like blood stains or other physical evidence that imprinted on the walls. Bullet holes would be something that should not be ruled out, and if bullet holes are present, they should be documented on the 3D exploded sketch before the drywall is removed via saw. Though it appears obvious that the knife was used in the crime, we do not know this for sure and should make sure to document everything and look for less apparent evidence. Even if there was an item introduced to the scene by an offender to throw off investigators, it is not the job of the criminal investigator processing the crime scene to jump to conclusions. The crime lab will be able to decipher with scientific certainty what is and is not an original element of the crime. Staging is common. For example, the offender may have taken items from the house to make it look like a burglary turned robbery, which went wrong. The official crime preliminary report should include the accurate sketch with the following details included: the name of the investigator and identifying badge number, a detailed location of the scene, such as the city, state, and street address. The living room should be noted as the center of the sketch. The date and exact time the sketch was first drawn in pencil. The evidence listing key, which shows evidence as it corresponds to a letter and the mark indicated in said key. A compass arrow to give direction, and the scale of the sketch should be included, or the words "not drawn to scale." I'm choosing to draw it to scale, where 1/4 inch equals 1 foot. The computer-aided design, which uses laser lights and takes up 25,000 measurements per second in 3D, may be utilized if available, for the scale of the scene is most accurate. I would request the CAD if available, for it gives the best portrayal of the serious crime, allowing for an accurate point of view and zooming up particular elements of the crime scene. The more comprehensive crime scene search using the strip search method. In order to collect evidence from the interior of the residence, I will assign roles to officers on the scene, briefing them to watch where they are stepping and not to act impulsively or without great care. Hasty actions will lead to valuable evidence being trampled and lost. The strip search method is what I have decided on, as it will allow for the interior of the crime scene to be searched from one end to the other with more than one forensic processing unit. The exterior of the property should be searched from one end to the other as well, switching to a grid search if necessary. Walking from one end of the scene to the opposite end of the scene, I will then turn around and cover ground to the right or left without stepping over the same spot twice. The rooms of the trailer should be searched in this method with special attention to the living room where the victim lies. Assigning a CSI or officer and myself to this section of the living room would allow the scene to be thoroughly checked. As I move from one end to the other, I will make sure that I shine my flashlight ahead of myself to ensure that I do not damage or carry away smaller pieces of physical evidence. Smaller items of physical evidence include wood chips, hair, paint flakes, glass fragments, or small fibers. If not careful, these may be lost before ever accounting for or observing them. If new pieces of physical evidence are uncovered, I will take note of it for documentation and videography. Things such as footprints inside and outside should be prepared to be photographed and videotaped. I must photograph and videotape the new evidence as well as log it in with the following information and account for the crime scene sketch: the time and date of the evidence discovery, the location that I found the evidence, the name of myself, of whichever officer, CSI, or criminal investigator discovered it. As this is a serious crime, I have chosen the specialized crime scene personnel will assist me. A description of the evidence, any identifying marks or further detail of the evidence, the name of the officer who assisted the find. This will ensure that there is no question that this was indeed an element of the original crime scene. This will save the investigator setbacks in court. All the information that is carefully recorded regarding the crime scene evidence aids the criminal report. The location of this evidence is very important, for it may give us the following information: establish the tracing of or identification of the suspect, establishing the suspect's modus operandi, MO, or identifying similar MOs via information added to the FBI's Violent Criminal Apprehension Program, VICAP, from the completed report, confirming alibis or exposing lies. Parenthetical, disproving the alibi. Connecting suspects to the crime or eliminating suspects, the identification of contraband, stolen property, and other illegal items, identifying victims if they are not identified. For example, we can't assume the woman lives at the residence before confirming it. A dead body may not be initially tied to the residence. Providing investigative leads. For example, checking into the husband or boyfriend and the location of the children based on the crime scene evidence is warranted, providing a statutory element of the offense. The collection of items of evidence. Like the crime scene photography, large items of physical evidence are taken first. This includes the disheveled furniture and children's furniture, cell phones and computer, if there, the knife and coat hanger. The body will be taken later by a CSI with a coroner for custody to wait for analysis by the forensic medical examiner trained to perform the autopsy. The knife should be examined for latent fingerprints to be logged separately. Same with the coat hanger, doorknobs around the house, upended furniture, cell phone, and virtually any physical evidence big enough to grab. Crimes of passions are rooted in emotionality and impulsivity. If this is the case, we can likely count on there being latent fingerprints on the doorknob and all over the knife and the victim. Smaller items of biological or trace evidence, such as hair and fiber from clothing, must be collected using metal forceps or tweezers so as to avoid damaging this delicate evidence, which may hold significant value in the criminal investigation. Fingerprints and footprints are class evidence to be taken with molds or a fingerprinting kit. Fingerprints should be entered into AFIS. I should use a swab where applicable to collect fluids or skin cells, which contain DNA. The shirt likely contains not only the blood of the woman, but the blood of the possible offender. DNA from biological evidence should be swabbed, placed in a vial, documented in notes, and in the container for the evidence chain of custody, and included to be sent to the crime lab. The shirt will later be bagged and taken separately as physical evidence. I should make sure to swab under the fingernails to see if the DNA of the offender is there. She likely dug into the skin. Is there evidence of sexual assault or semen present? This evidence should be marked, swabbed, and collected in a glass vial or cellophane bag. If the evidence of personization, did the offender take something, or did the offender display an excessive need for control over the victim as demonstrated by the possible sexual assault and murder? These are all observations to be recorded, though not conclusively. During the searching phase, the evidence should be marked with the following information. In the field notes and later in the evidence seal packaging, I am choosing to bag all evidence, not directly mark it, for it will be sent to the lab. The size of the object, the physical nature of the object. Is it solid or liquid? If the evidence is liquid, it should be always kept in an airtight container, such as cellophane bag or glass vial, and marked. The value of the object and the number of the like objects, the case number pertaining to the evidence, the date and time retrieved, the initials of the person who marked the evidence, BK in this case. This process should be done so as many times as needed. It may occur up to 1,000 or more times. It must be counted accurately, and the quantity should be accurately recorded on the container. Packing the evidence for the forensic lab. Each item I collect, included but not limited to the knife, coat hanger, the bloody clothing on the woman, must be packaged in the proper way for forensic lab analysis. I must use separate containers for evidence, not mixing things up or causing confusion, no matter how daunting this may be. I must use new, clean packaging that was previously used as to avoid contamination. Obviously, blood or biological evidence renders a container spent. Avoiding metal containers which can be reused is ideal to confirm the container is indeed disposed of afterwards. The package must be sealed with a strong medium, such as strong tape. Items of clothing need to be kept in as not folded. I must keep evidence that was found in the container and mark it as such. I must include a letter of transmittal to state what type of analysis must be done. For example, wound analysis, DNA or fingerprint, even ballistics. Again, I must account for all this evidence in the chain of custody form, where it was found, how, when, who is transporting it, and where the evidence was located. The woman must be removed by a certified professional and sealed, taken into custody by the coroner and sent to the forensic medical examiner for a forensic autopsy. This must be all logged in the field notes and the initial crime report before compiled in the closing report. Evidence of chain of custody inventory receipts, the careful description of evidence, when and where the evidence was found and who found it, are all related to the evidence chain of custody. All evidence must be described and then transported and placed in the evidence locker. The identity of the transporter and the location of the evidence locker must be accounted for. The evidence is taken out of the locker. It must be recorded who did so and why they did so. The knife, the misshapen wire coat hanger, and physical, biological, and trace evidence found must be accounted for, bagged, and sealed, and then kept in the evidence locker. Her body clothing should be examined as well, but this would infer that she must be moved and have the items of clothing removed. This is something that the Forensic Crime Scene Processing Unit should do. If she had a cell phone or computer nearby, this should be described, logged, and transported to the Digital Forensic Lab for digital forensic examination. Did she communicate with anyone? Did this communication indicate a conflict? Did her husband or boyfriend contact her? Did anyone else contact her? This may help investigators look in the right direction if things turn out to be not so obvious. Again, we can't assume it was the husband or boyfriend just because there may have been a history of domestic violence or a PFA, despite this being very common. Also, she may have children's furniture for her nieces or nephews, so we can't even assume that she had kids. When moved, all items will have inventory receipts, which documents the movement of the chain of custody. All this for the accountability and integrity of the evidence and thus the proper outcome of the criminal investigation. Failing to do so leads to injustice. There can be very clear link between victim and offender. But if this is not accounted for via chain of custody, then it will be inadmissible. Outreach to other agencies, immediate elements of the investigation. A lot of these inquiries would occur concurrently with the crime scene investigation. Does she have kids? The county record should often give us this information. If so, the welfare of the children should be ensured. Aware that they're disheveled, items of the furniture around the kids. Call the clerks of the court's office to see if there's any PFAs out on the husband or boyfriend that could be made. The husband or boyfriend of the deceased woman should be contacted to establish an alibi. He needs to be immediately located and questioned. The kids should be located as soon as possible, as an Amber Alert should be sent if they are not accounted for. Does the father have the rights to see the kids under normal circumstances? And did he take them? Neighbors should be questioned to see if the father was around or if any suspicious person was present. Anyone who normally passes by the scene, such as a mailman, should be questioned and an alibi established. When were the neighbors when this happened? These alibis should be evident and supported. Did they notice anything unusual? Maybe the father was seen with the kids leaving the scene. This could be important evidence that the father is not responding and the kids are not located. The Amber Alert can be set based upon the vehicle plate number description. Eyewitnesses and surveillance footage in the trailer park surrounding the area. Drugstore, which oversees the trailer, and nearby gas stations can give us information on this crime. Surveillance footage is circumstantial evidence, but may lead investigators in the right direction and the apprehension of the suspect. If we can't gather conclusive information by the end of the investigation, the FBI's Violent Criminal Apprehension Program can help. VICAP may be utilized in this case. Happens to be unrelated to a domestic dispute. This may be the work of a serial killer, though this is highly unlikely. Still, we are only looking at the facts of the investigation rather than conjecture, and we can only say for sure once the suspect is apprehended and the evidence is strong enough to say what happened with scientific certainty. The compilation of evidence in the preliminary report, progress report, closure report, and the prosecution report. My notes established that I wrote a thorough and accurate preliminary case report which contained all the facts of the case. I will need to update it with a progress report as we track down suspects and eventually create the closing and prosecution reports, which will be used in court if we get evidence of a specific person who committed the specific crime. The closure report will be the culmination of all the facts after investigation and lab analysis, which leads to the most accurate reconstruction of the crime scene. These steps that I have listed will ensure that the prosecution report and closure report reflect a proper investigative procedure with full admissibility of evidence into court. All the notifications were made and the evidence chain of custody and investigative procedures ensure the integrity and accuracy of the evidence at the crime scene. With thorough documentation, it is unlikely that the defense will be able to discredit the investigation and render evidence inadmissible. This clear information will allow the jury to deliberate based on all the evidence. Finally, adding this information to the FBI's National Incident-Based Report System, NIBRS, will allow the FBI's Uniform Crime Report to give a summative information of all the applicable crimes to help police officers, criminologists, and criminal investigators understand the social trends of crime, thus aiding future cases. Wow, ladies and gentlemen, I know that was a report based on a hypothetical murder of a female stabbing victim, but probably provides some relevance, at least the prosecutor will say, and probably the judge will agree, that it goes to show that the reason why there was not that much contamination at the scene is that, well, Bryan Kohberger knows what to do to avoid this contamination by a suspect. There's going to be information on the purchase of the knife, the mask that was over his head. There's also going to be some evidence of some overalls and things of that nature as well. So that's why it is relevant. Now, I'm sure Bryan Kohberger is going to be over there really questioning whether the appropriate foundation has been laid or the appropriate chain of custody has been followed at his trial, since he is quite certain. But I love it. It says the evidence must be done so that the defense, you know how those evil defense attorneys are, they just do whatever they want, right? With thorough documentation, it is unlikely that the defense will be able to discredit the investigation and render evidence inadmissible. Thus far, no evidence has been rendered inadmissible for Bryan Kohberger. So I wonder how he feels about that. Next on the docket, Luigi Mangione. He's having a bad day. That's right. The Trump administration is taking the rare steps in seeking the death penalty against Luigi Mangione for his alleged cold-blooded killing of the United Healthcare CEO Brian Thompson, pushing for what would be the first Manhattan federal execution in 70 years. Now, obviously, Luigi Mangione is accused of murdering Brian Thompson, who the prosecutor, the attorney general, in fact, said was an innocent man, a father of 2 young children, and this murder was premeditated, cold-blooded assassination that has shocked America, Pam Bondi said in her little statement. So after careful consideration, Pam Bondi has directed federal prosecutors to seek the death penalty in this case as they carry out the president's agenda to stop violent crime and to make America safe again. But Mangione's legal team shot back that a lawless Justice Department is trying to murder the 26-year-old alleged assassin for mere political reasons. While claiming to protect against murder, the federal government moves to commit the premeditated state-sponsored murder of Luigi. His attorneys put out in a statement, by doing this, they are defending the broken, immoral, and murderous healthcare industry that continues to terrorize the American people. New York State outlawed the death penalty in 2004, but federal prosecutors can still execute defendants if they convince a jury to unanimously sign off on the government-sanctioned killing. The feds last sought a capital punishment case in Manhattan in 2023 against Sayfulo Saipaz, who was convicted of killing 8 people and wounding several others after mowing them down in an ISIS-inspired rampage in the West Side Highway. But jurors couldn't reach a consensus on whether to sentence him to death, so he received 8 life sentences. I think the government's going to be very hard-pressed trying to get Luigi Mangione convicted based upon his popularity, his youth. But hey, you never know. You get the right jury on there. You never know what they will do, to say the least. Next, the Lori Vallow trial. Today, the jury selection for the Lori Vallow trial continues, day 2. And so, like I said, the jury selection continued for Lori Vallow, who is accused of conspiring to murder her former husband, Charles Vallow. Now, the jury pool dwindled from 200 to just over 50 jurors, and the judge also addressed a number of motions, including the state's attempt to exclude several of Lori Vallow's witnesses because some had not been subpoenaed. Some of the courtroom observers are saying that Lori Vallow is making eye contact with certain jurors, predominantly men. Remember, she has a way to put a spell on somebody. She's done it 5 times. Why not 6, I guess, right? Anyway, that's apparently it's obvious that she's trying to make eye contact with men and get them in her favor. But I'm sure if it's obvious to the courtroom personnel there, guess what? It's going to be obvious to the prosecutors, and they're going to put a female on there, as many as they can, because let's face it, women hate women. I told a story years ago about a trial that I did. It was a domestic dispute case. The whole morning just started off very poorly. They bring in the jury pool. It was almost nothing but women. I thought, oh my gosh, this is going to be terrible. And ultimately, we had an all-female jury. It was a misdemeanor case, so we only had 6 jurors, but 6 was enough. That is where I learned, when I'm selecting jurors, if the key witness is a female, we want a female on the jury because females generally hate females. Not saying why, not sure how it works, why it works. I'm just telling you, my experience is if the victim is a female, put on those female jurors on the jury. That's what Lori Vallow is trying to do. We'll see if it works for her, if she can put a spell on those jurors, or if they're going to look at the facts of the case. Obviously, she's entitled to the presumption of innocence. So, hey, there you go. And who knows? Maybe she'll just win. You never know. I mean, conspiracy with a dead guy, I don't know. Going to be interesting. Next, Karen Reed trials also beginning their jury selection. We're bringing both of these trials to you once they get going. And there in Massachusetts, 92 potential jurors were brought into the courtroom today as the jury selection began for the retrial of Karen Reed. Now, barriers have been placed up around the courthouse to keep people away. I think they're now up to 300 feet away from the courthouse. Now, the potential jurors had to complete a 3-page questionnaire, and it asked whether they had any preconceived opinions about the case and whether they, as a potential candidate as a juror, have any personal connection to drunk driving, domestic violence, or any other violent crime. The potential jurors were also asked about their exposure to the previous coverage of the case and whether they could stop themselves from consuming news coverage while they were on to the jury. Anyway, at the end of the day, the court clerk confirmed that 2 jurors were seated out of the 62 who were actually questioned. So there you go. Now, the judge expanded the buffer zone outside the courtroom because jurors from the first trial reported hearing demonstrations outside screaming and yelling during their deliberations. And the judge said that the zone is necessary to prevent outside influence, interruption, or distractions. So that's good. And law enforcement officials are apparently sharing a QR code to demonstrators, which directs them to the judge's order about the buffer zone if they have any questions. Go to the little code here. The supporters of Karen Reed think that's unfair. Now, obviously, Ms. Reed has pled not guilty to the accusations and the charges of second-degree murder and sundry of other charges. And the prosecution says that she hit her boyfriend, John O'Keefe, with her vehicle outside the home in Canton during a snowstorm back in January of 2022, following a night of drinking. Her defense team has argued someone else has been responsible or is responsible for killing Officer O'Keefe. Now, the defense centered on allegations of a cover-up involving members of several law enforcement agencies. And they say O'Keefe was beaten inside a home, bitten by a dog, and then left to die out in the cold. Well, the first trial resulted in a mistrial, so here we go again. I'll just tell you, bottom line, ladies and gentlemen, the defense never fares better on the second time around. I know you're probably tired of hearing me say that, but I'm telling you, the prosecution fixes their errors. They fix their troubles. And we've seen that the prosecution is basically tried to dismantle the defense, and they've done a pretty good job of it thus far. Obviously, we're going to have to wait and see, watch the trial. Let's see what happens. We'll be bringing it to you live, so make sure you watch it here on Crime Talk. Next on the docket, a 75-year-old woman has been charged with the murder of her child 55 years ago. Not something you hear about every day, that's for sure. So a Louisiana mother has been charged with murdering her baby nearly 55 years after claiming he fell out of the crib. As authorities uncovered old, hateful letters detailing how she wished the child was dead. Alice Rollison Bunch Idlet, now 75, was arrested last Thursday and charged with second-degree murder in the 1970 death of her 16-month-old baby, Earl Dwayne Bunch III. At the time, the then 20-year-old mother claimed her son fractured his skull falling from the crib, but a cold case investigation launched in 2022 decided that was a homicide. Now, baby Earl was covered in bruises as well as a bite and burn marks, and his mother wrote some disturbing letters to her then husband, Earl Bunch Jr., about hating and wanting to kill their son, according to the arrest affidavit. I just got through whipping that little bastard. I hate him. That's the honest truth, she allegedly wrote to her husband, who was stationed in Thailand during the Vietnam War at the time. I can't stand this life. God had to punish me by letting me have this little brat. I wish I would have died when he was born. I hate myself, she wrote. And these documents first shared in 1985 as part of a divorce and custody battle over their other daughter. I'll kill him before he becomes spoiled, she allegedly threatened in one. I honestly mean that. Idlet frequently wrote of the hatred for the child, according to the court documents, which quoted her as telling her husband in one letter, if he starts crying when I put him down to play, I am going to whip him until his darn seat is red. I hate your son. I wish he was dead. Now, at the time, the doctors noted that the injuries were not consistent with a fall, but the mother denied doing anything to her son, later telling her husband he probably fractured his skull when he fell out of bed at his grandmother's house. The boy's father did not alert authorities to the alarming letters at the time. He testified that he accepted his son's death as accidental because he could not believe that the woman he loved could have harmed their son. The case was ultimately closed due to lack of evidence and remained untouched for years until the 2022 investigation, which resulted in the district attorney's office convening a grand jury and charging Miss Idlet with second-degree murder. She's currently behind bars on a $950,000 bond. What do I say, ladies and gentlemen? It's always the defendant's own words that get them. What do we say about cold cases? Somewhere, someone knows something, because nobody can keep a secret. They got to talk about it. They got to tell somebody. They brag about it. It's just the way it is, ladies and gentlemen. The truth comes out. It may take some time, but the truth always comes out. Next, this day in legal history. On April 1st, 1789, the United States House of Representatives held its first full meeting in New York. On this day in 1834, the U.S. Senate censored President Andrew Jackson in a dispute that stemmed from his actions during the Bank War. On this date in 1947, Jackie Robinson signs with the Brooklyn Dodgers, breaking the MLB's color barrier, obviously a significant milestone in civil rights, and it challenged discriminatory practices. On this date in 1970, on April 1st, 1970, Richard Nixon signed the Public Health Cigarette Smoking Act, which banned cigarette advertisement on television and radio in the United States. And on this date, April 1st, 1998, a federal judge dismisses a sexual harassment lawsuit against then-President Bill Clinton, a significant legal ruling during his presidency. That's right. Can't be distracted with those lawsuits while you are the commander-in-chief. Now, when you get out of office, they can harass you all they want, but not while you're in office. And then finally today, our dumb criminal of the day. A Florida woman has been charged with felony battery for attacking a male acquaintance with what has been described as a deadly weapon. Anything can be a deadly weapon, ladies and gentlemen. I've seen it be a shoe. I've seen it be a pillow. But this one, the deadly weapon is described as a large conch shell with barnacles. That's right. The police have charged that Nikki Quarterman was extremely intoxicated when she got into a verbal domestic-related argument with a 63-year-old male victim. The pair had been in an on-and-off relationship, apparently over the past decade, according to the court documents. And after the argument, Quarterman took her clothes off and started to break everything in the victim's St. Petersburg residence. Then, after the man got to Miss Quarterman to ultimately go outside, she allegedly grabbed a 10 to 12-inch dried conch shell and swung it at the victim multiple times. Miss Quarterman then threw the shell at the victim, who suffered a laceration on his right hand when he sought to block the incoming shell. That's right. She then locked herself in the garage, but was taken into custody after a brief struggle with police. After posting a $15,000 bond, Ms. Quarterman was released yesterday from the county jail. Needless to say, she can have no contact with the victim and no contact with items that can be considered deadly weapons like conch shells. That's all we have for you, ladies and gentlemen. Thanks for watching. We'll see you next time. Have a wonderful day. And remember, the Constitution matters.